Thank you, Your Honor. Ladies and gentlemen of the jury, we're about to turn the case over to you to go back into the jury room and deliberate and come back with a verdict in this case. But this case is a little different. We are going to ask you to deliver a liability verdict only before we get to the damages. Why are we splitting this case in two? Quite frankly, the case against one defendant is very simple. He was a drunk driver out on the road who lost control of a vehicle and ran into our client Lauren and paralyzed her, severing her spinal cord and mangling it so that she will never walk again. However, we have brought a case against the employer as well. The employer has fought this case tooth and nail. You've heard their testimony. You've heard the witnesses testify. You've heard their experts try to claim that they can have no responsibility because they had no way of knowing that this accident would happen. You've heard them put on one of their managers who testified that he did not know that the driver had a drinking problem. Ladies and gentlemen, there are two basic ways to hold an employer liable for an employee's negligent conduct. One, there's a Latin term called respondeat superior. That's fancy for saying an employer is liable, responsible for damages caused by the negligence of its employees in the course and scope of their employment, while they're working, while they're on the job. Ladies and gentlemen, this incident, there is no doubt, occurred during a daily drunken delivery run by the defendant driver while he was working for his employer, the other defendant. There's no doubt about that. But the defendant argues there's no way we should be responsible. The moment the defendant driver took glass to lips and started drinking, he could not be considered in the course and scope of his employment, and anything that occurred after he did that should not be their responsibility. Ladies and gentlemen, the judge has instructed you on another theory of responsibility, and that is called negligent entrustment, another fancy term, which basically means that the employer is liable if we can show that they knew they gave the keys to the truck to someone they shouldn't and allowed him to drive their vehicle for them. It's their own negligence. And yes, their manager testified he did not know, he hadn't heard a thing. But you also heard 5 employees testify that they knew that this defendant driver had a habit of going out at lunch and drinking and having daily drunken delivery runs. They testified that they told management, and then we pulled the personnel file and all the issues and citations that were given to this defendant driver by the company, by the police, during the time he was on the road for drunken driving. Don't listen to their plea of, we were so short-handed we had to get the packages delivered. People could have waited another day for a package instead of Lauren being stricken, paralyzed, to lose the one thing that she loved so much, running. Ladies and gentlemen, we ask you to come down with a guilty verdict, a liability verdict against the defendant employer as well as the driver. They knew, despite their protestations that they didn't, that this driver was a hazard, and they gave him the keys to the truck to paralyze